It, it fails many years, not of its own weight, of other things that it gets attached to. No, up till now it may have been. Up till now, but we're going to correct that this year. But we may be back here doing this again next year, if so we'll see. Any other discussion? Okay, seeing none. So I've already made the motion. We've got the second. So Michelle, please call the roll.
Senator Cierpoit.
Aye.
Fitzwater. Bean. Aye. Bernsketter. Esslinger. May. McCreary. Mosley. Rowden. Thompson Raider. Trent.
Michelle, Tracy, I'm sorry,
Got it,
Senator
got it,
McCray
okay.
voted yes. Okay, with the chair. Nine, nothing. By a vote of 9-0, we have voted do pass Senate Bill 1470. I move that we leave executive session. Do I have a second? All in favor, please say aye. Aye. Opposed? No? Ayes appear to have it. Ayes do have it. We're out of executive session. This morning we're going to hear two bills, Senate Bill 1419 and Senate Bill 1466. I think 1419 is going to be less controversial, so I think I'm going to hear it first. Senator Beck, are you ready?
Good morning, Mr. Chair and members of the committee. For the record, I'm Senator Doug Beck, District 1. I'm introducing Senate Bill 1419, which modifies the membership requirements in the Clean Water Commission. Currently, a provision in the legislature, at least 2 members shall be knowledgeable concerning the needs of agriculture, industry, or mining, and interested in protecting these needs. Senate Bill 1419 modifies these by stating that there should be a member who is knowledgeable in each of the areas mentioned, along with adding the requirement that a member is knowledgeable in the needs of publicly owned wastewater treatment works. Additionally, 4 members of the commission need to represent the public. Furthermore, SB 1419 is introducing a provision that prevents conflicts of interest by stating that the governor should not appoint any person who has a substantial interest as defined in section 15.450 in any business regulated by the commission, and the commission itself shall establish rules which specify when members should exempt themselves from voting due to conflict of interest. Finally, I would like to thank the committee for taking this time to listen to Senate Bill 1419, and I'll be more than happy to answer any questions that you may have, and we also have some folks coming up that will testify in favor of that. On a personal note, I think as we go through, as the years come along, clean water is going to be very, very important across not only Missouri but the entire world. And as we see things happening, and as we drive across the rivers that we see that are lower than they've ever been, and I can actually see on the Merrimack River in St. Louis, it looks like rapids now. It's like that close to the bottom. So there's concerns out there, and we need to look at these issues as we go forward. And this bill would help that in the public interest of having good, clean water. Thanks.
Thank you, Senator. On the last page, it says if you're absent, you're changing it from 6 to 4 consecutive meetings. You'll be deemed to have been resigned. Is there a reason that you can tell us why we're going from 6 to 4?
On the last page, say it again.
We're going from, it says you're deemed to have resigned if you're changing it from 6 meetings, if you've missed 6 meetings, to if you've missed 4 meetings. Is there something that's triggered that?
We can discuss that. I'll be honest with you. Yeah, we can discuss that.
Okay, I'm sorry. I wasn't trying to trick you. I just was curious what that is. I'll wait for your witnesses to come forward. Senators, anybody have a question for Senator Beck? Seeing none. How many people want to testify in favor of this bill? How many in opposition? Okay, the first person in favor, please come forward. Leave your witness form and let us know who you are.
Mr. Chairman, members of the committee, my name is Kaina Iman. On behalf of the Metropolitan St. Louis Sewer District, we're here to testify in support of Senate Bill 1419. MSD has a really good working relationship with the current members of the Clean Water Commission, but the way the statute's currently drafted, it really narrows and limits the number of people who could serve on the commission. We feel that removing that 2-year cooling off period would allow some of our employees or retired directors to serve on the commission. And since they do have a vested interest in clean waters of the state, we feel like this would be important. So I'm happy to answer any questions.
Thank you. Questions for Kaina?
And I understand the 6 went to 4 because that brings them in line with the other DNR commissions have.
Is that right? Okay. Thank you. Any questions for Kaina? Seeing none, thank you very much. Next in favor, please come forward.
Senators, thank you for the opportunity. My name is Tim Gibbons. I'm with the Missouri Rural Crisis Center. We're a statewide farm and rural membership organization. We've been working on this issue since 2016. We're writing to respectfully request that you pass SB 1419. Similar to foreign ownership of farmland in our state, history is sort of forgotten on this issue. In 2016, House Bill 1713 contained a very harmful provision that was added by a Senate floor amendment to the underlying bill during the last 2 weeks of the legislative session. The language pertains to the issue we're talking about right now. It was never a standalone bill, and it was never publicly heard in the committee. The governor vetoed the bill, 1713, and the legislature overrode that veto. We know what the bill's doing. I want to also echo Senator Beck's issue on water and the importance of water to family farmers and rural people in our state and people that get drinking water from groundwater. It changed the commission from requiring that the public be represented to not requiring that the public be represented. The motivation behind the change was in response to the Clean Water Commission's appropriate decision to reverse the Administrative Hearing Commission's recommendation to the Clean Water Commission sent on December 24, 2015 regarding the issuance of a CAFO operating permit for a Pipestone hog operation. Pipestone is a folding LLC corporation out of Pipestone, Minnesota. They also own and manage hogs in China. The Clean Water Commission modified the Administrative Hearing Commission's recommendation, saying that they shouldn't have issued the permit because the CAFO in Trenton, in Grundy County, could have been in a 100-year floodplain, and that it didn't have continuing authority. And if you remember the issue a few years ago about continuing authority, which is they don't have money. They're folding LLC corporations, so they have LLC on top of LLC on top of LLC, so they don't have money. So enough money in their bank account to operate and to clean up and to close down the operation if need be. So that's why the Clean Water Commission denied the permit. The first and only appearance of this language occurred when Senator Munzlinger introduced it as a floor amendment on May 5th, 7 days before the end of the 2016 legislative session. It was added by voice vote and was passed with many legislators unfamiliar with the consequences of the language. Once again, it was never a standalone bill and never heard in committee. There's a little bit more here, but I just want to say that the history of this bill is important. When corporations don't get their way, they oftentimes come to the legislature and make it that their way is possible. I also know that the Clean Water Commission, after this language was changed, was sort of gutted gutted of experts that knew about a lot of clean water. So if you have any questions, I appreciate the opportunity. Thank you, Senator Beck.
Questions for this? Senator Bernstein.
Thank you, Mr. Chairman. You mentioned it could be possibly in the 100-year floodplain.
It says that the Administrative Hearing Commission didn't offer proper evidence to show that it wasn't in a 100-year floodplain. So the Administrative Hearing Commission or the Clean Water Commission was saying that they had to actually give evidence that it wasn't in a 100-year floodplain.
I mean, the floodplains are posted. I can look and see what property's in a floodplain.
Well, apparently they didn't do that on the application, and that's what the Clean Water Commission was saying they needed to do.
So who would not qualify to be on this commission under this legislation?
The requirement that the public be represented was taken away from the Clean Water Commission in House Bill 1713 in 2016.
So what person on the board wouldn't qualify now that's on the board?
No, it wasn't that some people couldn't qualify. It was that the public was not, the requirement wasn't that the public be represented. Prior to this bill being here, the public had to be represented on the Clean Water Commission.
Okay, thank you.
Thank
Thank you, Mr. Chairman.
Any other questions? Seeing none. Thank you
I
very much.
appreciate you. Thank you.
Oh, I'm sorry. Just a second. Senator May.
Excuse me, what year was that, House Bill 1713?
2016, it was, the veto letter was
2016.
dated 6/28/2016.
Okay, very good, thank you.
Thank you, Senator. Thank you, Senator.
Thank you. Next in favor, please come forward. Again, make sure you leave your witness form and let us know who you are. Ready?
Thank you, Mr. Chairman and members of the committee. My name is John Madras, and I'm speaking on behalf of the Sierra Club. We are in favor of this because it restores accountability and public trust into a body that appears to lack it at the present time. It also puts the commission in the position to represent the diverse interests that often come about with water resources, including water supply, fisheries, floodplain management, and other aspects that are not entirely represented by the permitted or regulated universe of people. The Commission's responsibilities are broader than just the operation of business, and we need to recognize that in their operations. As an example where the Commission has looked at some problems that were very problematic for businesses, they have successfully worked through them under the former configuration of the Commission itself. As an example, I would point to the problems experienced earlier at Table Rock Lake. Pardon me. In the 90s, there was a problem with eutrophication, algae, in Table Rock Lake, and the resulting solution that needed to happen was to limit the amount of phosphorus discharged by wastewater treatment plants in the Table Rock watershed, mostly the James River watershed basin in Missouri. This was a monumental undertaking. It cost a lot of money, but the Commission was able to work through it by talking to all the different people who were involved in this process and came up with a solution that gives us the wonderful recreational resource that is there today. It was not cheap, it was not easy, and it wasn't fast either. It took 20 years to be able to restore Table Rock Lake to the position that it was. But through the negotiation of the general population of the Commission, they worked through rules, they worked through permits, they worked through all the different hoops to make that happen. The Commission is not done with meeting problems that will come before it like that. With the changes that we see in flow conditions, droughts, floods, and other things like that, there will be more challenges to come before the Commission, and having a generalist attitude toward the people in the Commission, a problem-solving attitude from the ways that they can approach problems is always an advantage. Surely they will need to take care of the businesses that need to stay in business, and we appreciate that. We also recognize that the business perspective is different than the natural resource management perspective. There are different costs, there are different timelines, there are a lot of different changes, sometimes in culture, sometimes in operations, that need to be worked through to make solutions happen for the best of everyone. And so that's why we appreciate the opportunity to speak on this bill. And also, Mr. Chairman, in answer to your question about the change from 4 to 6, for the first 35 years of the Clean Water Commission, they've met every other month. And so 6 meetings was about a year. In recent times, they've gone to quarterly meetings, and so the same time frame would still apply. 4 quarterly meetings or 6 bi-monthly meetings.
All right, thank you. Any questions for this witness? Seeing none, thank you very much. Next in favor, please come forward. No, got the next guy. Oh, okay.
Hello, my name is Ethan Duke. I'm with the Missouri River Bird Observatory, which is an affiliate member of the Conservation Federation of Missouri. So I'm here representing the Conservation Federation today. I'm sure many of you have heard of it, but I'm one of 100 different affiliate organizations that are members of it, ranging from fly fishing groups to all sorts of groups that, hunting and trapping groups, all sorts of recreational uses of our natural resources are represented by that organization. And they get together every year and have a very deliberative process like this one here, where they debate and discuss and come up with resolutions. And it takes weeks and months. People take their extra spare time to come and do this, and they're also not don't have like outside influences, so they remain pretty pure in their intentions. And during that process that they go through, making resolutions to protect our natural resources, they came up with a great resolution a couple years ago that specifically addresses this piece of legislation. And it mentions, there's a lot of whereases and things involved with it, but it mentions several things that the gentleman just mentioned here as the prior precedent and the way that it worked before. And then when the House bill, it was 1713 that came through before, that was passed by the General Assembly in 2016, which included an amendment to remove the mandatory public interest majority on the commission. So there's a lot of whereases and wherefores, and you know that we're true to our mission to protect these natural resources that we all depend on. And so it's just kind of that great commonsensical thing. There's a lot of industry influence there that are doing their jobs to look out for their industries, and that's nothing really wrong with that. That's what they're supposed to do. But this is looking out to protect the resources, so it's kind of like that old cliche about the fox watching the hen house. And so that's kind of why we're here to support this, and hopefully you hear it through. We appreciate that.
Thank you very much. Questions for this witness? Seeing none, thank you very much. Next in favor, please come forward.
Good morning. My name is Ramona with the Missouri Municipal League. And on behalf of the Missouri Municipal League and the 650 cities, towns, and villages that we represent, we would like to voice our support for Senate Bill 1419. We feel the changes will provide for more diverse voices and perspectives on the Clean Water Commission, and in turn keep our clean water for our municipalities.
Thank you for your testimony. Any questions to this witness? Seeing none, thank you very much, Ramona. Next in favor, please come forward.
Morning, Chairman, members of the committee. My name is Melissa Vatterat. I work for Missouri Coalition for the Environment. I am really grateful for this bill and have a couple of things that I want to articulate. One, a direct experience that MCE had that relates to why this language is so important, and then also to address some of the detailed provisions that I heard some questions about earlier that I feel like I could maybe help. So, the current statutory requirements, you've been hearing from other folks about the 2016 change. The way that it's laid out now has led to a Clean Water Commission that seems to be favoring industry over all the other interests, and the commission is the name of it is clean water. We need to be thinking about balancing the interests of industry, public health, wildlife, all of those things, and I think the idea of reinstating the public majority would really be positive for balancing all those interests. Just last year, MCE had a direct interaction with the Clean Water Commission that I think is pretty significant that I'd like to share. So the Clean Water Commission in the spring of last year denied DNR's request to begin a rulemaking to have rules related to cyanobacteria. I'm sure you're like, what is that? Algal blooms, the slimy, gross green things that will show up on the surface of your lakes. Cyanobacteria, cyanotoxins are generated and create these harmful algal blooms. DNR currently still has information on their website that says, be careful in summer months when you're in Missouri water bodies, especially if you see signs of harmful algal blooms. So MCE had petitioned DNR in 2021 to consider this concept of a new rule. And we wrote a very detailed petition. DNR said, this seems worthwhile. But they were still very thorough. They had 2 stakeholder meetings. They had a workshop to educate people not only on what the petition was, but also what are cyanobacteria, because it's a term I didn't know until we submitted this petition. Ultimately, after hearing from, for all those months of the workshop and the community, the stakeholder meetings rather, DNR was persuaded, yes, we should move forward with a new rule as MCE petitioned. DNR has this concept, and I'm not the expert in the room on DNR's evaluation of their rules, but it's my understanding they have a system called the triennial review. So they take certain components of their rules at a certain rotation, if you will, and DNR was asking the Clean Water Commission, can we begin this rulemaking now as opposed to when this section would come up later down the line? And the Clean Water Commission said no. So despite all of the science and the detailed outreach and consideration and DNR bringing it to them saying, we want to do this, the Clean Water Commission still said no. And I think that is a sign that if we can reinstate the public majority on this commission, there will be a better balance of considerations in terms of what Missourians need from our water resources. If we can't recreate in our lakes and our reservoirs because we have all these harmful algal blooms, I'm not going to give you all the details, but we know that tourism is a big industry in our state, and I think that would have an impact. So, just wanted to give you that specific example, and then wanted to also flag that 60 organizations, farms, and businesses wrote Senator Beck in February asking him to move forward with considering writing language that addresses these concerns. And so I have put in a footnote access to that letter in this, and I'll send you a digital copy as well. So just wanted to let you know that represents urban and rural folks across the state that are really interested in seeing that the public majority is reinstated. A couple last things I just wanted to say. Yeah, the 4 to 6 had to do with the fact that, like
right, we got that.
Matter said just a moment ago, there's that history and how the frequency of the meetings have changed. Also, there are other commissions that are only having that.
Okay.
If you miss 4.
Yeah, we got that.
You got
Okay.
it. Okay, great. And then, that's all I have for now.
Thank you very much. Anybody have questions for this witness? Seeing none, thank you very much. How many people are left in favor? Okay, please come forward and be as brief as you can. We have to get out of this room in a little while. Let us know who you are and begin your testimony.
Mr. Chairman, members of the committee, my name is Steve Jeffrey. I'm an attorney. I'm here representing several farmers and ranchers who live in Livingston County as well as Cooper County. Their position is to support this legislation. I will be brief. I do have some prepared remarks which I'll leave with my appearance form, but just in a historical context, the Clean Water Commission was created in 1972 by Senate Bill 424. At that time, there were 6 members of the commission, and there is a specific limitation that no more than 2 members can be representative of agriculture, industry, or mining. The next time the composition of the Clean Water Commission was changed was in 2002 in Senate Bill 708, which increased the commission to 7 members, and the 7th member was reserved for someone who is representative and knowledgeable about publicly owned treatment works, basically someone knowledgeable about municipal sewer systems. And significantly, the 2-member limitation for agriculture, industry, and mining remained intact. Fast forward to February 24th, 2016. In a case in which I was the attorney of record, the Clean Water Commission voted 4-2 to revoke a CAFO permit for a CAFO that was proposed to be built in Grundy County. And I think there was some testimony by a previous witness about floodplain that's really not relevant to the point here, but fast forward to May 5th, 2016, just a couple of months later, in consideration of House Bill 1713, on the Senate side, Senate Amendment 1 was offered. What Senate Amendment 1 did was change the membership components of the Clean Water Commission in 2 respects. Number 1, it eliminated the 2-member restriction on agricultural, mining, and industry representation, and it eliminated the requirement that 4 members be a representative of the public interest. So in effect, what was first passed in 1972, the two-member limitation and the 4-person requirement for public membership was flipped. As a result, it appears in response to this CAFO permit appeal. Significantly, the changes made by Senate Amendment 1 were approved by the Senate that same day on May the 5th, 2016. Those changes were never addressed in any committee hearing. They were never subjected to any type of public input or public review. After the governor, subsequently House Bill 1713 was passed, the governor vetoed it. His veto was overridden. And so what had been in place from 1972 to 2016, 44 years of precedent in which this 2-member limit and the 4 public interest representatives on the commission, what was worked successfully for 44 years changed. So since that point, there is significant information. Again, some of the previous witnesses have mentioned this. Doing this switch in 2016 has resulted in some what some would consider poor policy choices. Case for example, recently the Grand River and the Thompson River in northwest Missouri were placed on what's called the impaired waters list under Section 303D of the Clean Water Act. The reason that these 2 rivers and their watersheds were placed on this list for impaired waters was due to the presence of E. coli. So if you have an impaired river for E. coli, it's natural to determine, well, maybe we should figure out where the E. coli is coming from. So there was a proposal submitted by the Department of Natural Resources to the Clean Water Commission to do some microbial testing for E. coli to determine the sources of the E. coli. After significant lobbying by several agribusiness trade associations, the Clean Water Commission, whose membership at that point of the 7 members, the 1 representing the municipal sewer background, and then the other 6, all with ties and relationships either to agricultural industry, declined to accept that recommendation from the department, and in that case, that rule was not accepted. So at this point, these 2 streams remain on the impaired waters list, but no one has any way determining why they're impaired, where the impairment is coming from. So that's just an example of one of these poor policy choices. So my clients would urge the committee to pass this bill, restore the prior history of the clean, membership composition of the commission that worked successfully for over 44 years, that was changed only in what appears to be a knee-jerk reaction to 1 CAFO permit that got revoked. And to wrap things up, what I want to do is just quote briefly, in his State of the Union address in 1984, President Reagan said, preservation of the environment is not a liberal cause, it's not a conservative cause, it's just common sense. My clients would urge that the committee members use their common sense and support Senator Beck's bill.
Thank you. Questions
Glad
for
to
this
answer any
witness?
questions.
Seeing none. Thank you, sir, very much. Next in favor, please come forward.
My name's Emily Crawford, and I live in Hickory County, and I just want to say that I want this bill to pass.
Next in favor, please come forward. That's perfect.
Good morning.
Good morning.
Thank you for hearing all of us today. My name is Trina Crawford. I'm also from Hickory County. And I just represent the common folk who sit down at home with our own busy lives that have nothing to do with politics or what happens on the big hill. We just go on with our lives trusting that y'all have our backs and our best interest for us, our planet, our future generations to come and live in that planet. And all the facts have pretty much been laid out for you today. I just want to come with heart and remind you that we rely on you to go back and sometimes backpedal and make some corrections, like some, you know, they slid that right through in 2016, and it was a few years before, you know, organizations, nonprofits, people who are, you know, down on the floor looking out for us and coming up here and talking to you folks for us, started noticing. And so I'm glad that enough attention was brought to it, and Senator Beck had the bravery, the know-how, and was here in the position to do it all and get this all typed up for you folks. And I just am going to pray that you keep our best interest at heart and learn about CAFOs and learn about Michigan or Minnesota and Iowa and the situations with their waterways, because there are going to be a lot more of these bills being delved into by a lot more of us little groups. One just sprung up that I am a part of, Protect Pomme de Terre in Hickory County, and hopefully more little groups like us will pop up across the country and start delving into these old bills and new bills and joining you all in this great fight. Thank you very much.
Thank you. Any questions to this witness? Seeing none, thank you. Anybody else in support?
Good morning, everyone. My name is Dana Ripper. I'm from Saline County, Missouri. I am a member of many of the groups that have testified here today: Missouri Rural Crisis Center, Conservation Federation of Missouri. But I'm just here as a resident of Missouri. I have to apologize. I really don't have prepared remarks. Right now, I'm supposed to be at a grassland conservation conference down the street at the Capitol Plaza Hotel. The reason I bring this up is actually to invite folks on this committee and in the room to come to that conference. It is very much related to the bill that we're talking about today. It's a lot of folks that come together for soil and water health, including a lot of private cattle producers. So really interesting conference. But I wanted to say, as just a regular Missouri citizen, basically I wanted to come here and say thank you to you, Senator Beck, and thank you to you, Chairman Cierpoit, for bringing this up for hearing. I think the previous witness just then said it best. We do rely on folks in these chambers to protect us as citizens. It feels often as though industry has a much, much louder voice than us as citizens. As, again, another previous witness said, industry needs to look out for their own. That's what they do, and that's okay. But there's more than 6 million Missourians who also need representation, and this is, I think, a perfect example of a really good bill that does sort of bring back representation to the average Missourian. I think we all want clean water, and I think that restoring the public majority on the Clean Water Commission will help us get a long way down that road. So I really hope that you all vote this yes out of committee.
Thank you very much. Anybody have questions for this witness? Seeing none, thank you.
Thank you.
Anybody else in favor? Anybody in opposition?
Thank you very much, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate, and I'm in favor of Senate Bill 1419. This provides a more playing field over big lobbyists, and it creates an even keel playing field across Missouri. So I feel having one from agriculture, one from the mining industry, one from the waste industry, and of course 4 from the public, which the public really needs to be in control of our clean water and fresh water of the Clean Water Commission. This makes a lot of sense, It's about time that Missourians come first in this General Assembly over any big business and profit. And so I urge every one of you, regardless of your party affiliation, I'm Republican conservative. I can't believe I'm backing this Democratic philosophy or introduction of a bill, but here I am in support of this bill. I believe putting Missourians, or 6 million Missourians first over big business comes first and foremost, and therefore I highly support SB 1419.
Thank you. Any questions for Arnie? Seeing none, thank you very much. Anybody else in favor? Anybody in opposition? Senator Beck, thank you very much for presenting the bill today.
I appreciate it. Thank you. Thank you, Mr. Chair.
Next
Somebody
up,
left
we'll-
their phone up here too, by the way. So.
Somebody left their phone on the...
I'll bring it back.
Next, we'll hear Senate Bill 1466, Senator Schroer.
Thank you, Mr. Chairman, members of the committee. For the record, Senator Schroer on Senate Bill 1466. And for the record, there's another committee waiting for me for executive session. So as soon as I wrap up, say questions, I'm going to run down there, and then we'll return. Senate Bill 1466 is an act that aims to address a complex issue of urban blight and redevelopment by ensuring fair compensation for all parties involved. Specifically, it mandates that in cases where a land clearance for redevelopment
Senator,
authority...
is the microphone on?
It is on, but
I think the acoustics in here are something that, I'm getting texts from people that can't hear outside the building either, so I'm sorry to interrupt you.
Let's see. Is that any better? I turned it off and on again.
Yes, you just got to get real close to it. Sorry, thank you.
So Senate Bill 1466 specifically mandates that in cases where a land clearance for redevelopment authority exercises eminent domain to acquire qualified properties defined within the act, the authority must compensate the mortgage broker or the mortgage holder for any shortfall between the mortgage amount and the final adjudicated award for the property. One of the primary motivations behind this provision is to mitigate the financial risk borne by banks in blighted areas. When a city seizes property owned by a developer without adequately compensating for the mortgage lien, the burden of financial loss ultimately falls squarely on the bank. This creates a disincentive for the banks to invest in these areas as they become wary of heightened risk. Consequently, this could result in reduced investment and redevelopment activity in the very communities that they are most in need of revitalization. And these LCRAs are across the state. They're in Kansas City, St. Louis City, St. Louis County, Springfield, Lake of the Ozarks, Sikeston, and several other spots throughout Missouri. By ensuring that the banks are compensated for their risk in the properties, this legislation seeks to encourage continued investment in these blighted areas, thereby fostering economic development and revitalization. Moreover, by mitigating the risk for banks, it aims to stabilize interest rates and facilitate access to financing for developers, ultimately promoting sustainable growth and renewal in these urban communities. So with that, I would be open to any questions. I will say that there's a couple different amendments that I'm working on with Senator Washington that she's pointed out, and I think it's a good idea to add into this bill.
Thank you. Questions for Senator? Seeing none. How many people want to testify in favor of this bill? How many people in opposition? Okay, so nobody in favor. So first person in opposition, please come forward.
Good morning, Senators.
Make sure you use the microphone, okay? We have people
Try.
off-site that are listening, so.
Is that any better?
Just talk to it as close as you can.
I will.
Okay.
My name is Jerry Carmody. I'm a lawyer in St. Louis with the firm of Carmody McDonald, and as such have done a lot of work for the Land Clearance for Redevelopment Authority of the City of St. Louis, for the St. Louis Development Corporation, and in particular, in the context of this proposed bill, I'd suggest that we had a very active role in assembling the land for the NGA project, 100 acres. And so we confronted what would have been an impossible situation if this bill were in place, to have acquired all of that property to assemble and turn over to the NGA for what we think is a great development in North St. Louis. I'd like to just start to make sure you understand the essence of the bill. You may know, but I know that some respects kind of an esoteric topic, condemnation. So let me explain to you the way that it works now vis-a-vis this bill versus what would be modified if you pass this bill. The way that that it works now in a condemnation proceeding is that there is one value set for whatever is being acquired by the condemning authority. So let's take, for instance, a building, an office building, a vacant lot, doesn't matter. What ends up in a condemnation case is that a single amount is set for the fair market value of the property. That's what the Missouri Constitution requires, just compensation, and so forth. From that individual number, that one number, anybody that has an interest, including lenders, including banks, historically, decade after decade, century after century, and I was involved in a lot of the new legislative effort, the last go-through, when a lot of the statutes were enacted, changing a little bit of the laws of condemnation. Never, ever have I seen in my more 40, 50 years of practice, and a lot of it in this area, never have I seen a suggestion like the one before you today. And that is that we will not just set that price for the value of the property, but whatever liens are on that property, we are going to require the condemning authority to pay for. That, in the circumstance for which this legislation was drafted, would make it impossible to achieve the very purpose of the Land Clearance for Redevelopment Authority. What would happen is a situation, if you can imagine, I've bought a house for $100,000. I show up at the closing, and I'm told at the closing when I've got my cashier's check for $100,000 that, well, wait a minute, the seller says you need to pay the $200,000 that he or she owes on that very property. Well, why should I have to pay that $200,000 or $300,000 that the bank lent for that property? If the bank took the risk, it's going to get the reward when the rewards come, but also part of that risk is that you don't get everything back. What you would say in this situation is that you're at that title company ready to close. You must come forward with the other $200,000, though it has absolutely no relationship to anything. So what is it that really happened here? And when you analyze the bill, think about, number one, why does it only relate to LCRA? Why does it only relate to distressed communities? All right, think about that. LCRA and distressed communities are the only areas where there would be any activity in connection with this bill. So why is it that we have a bill that is targeted towards the people in the areas that most need redevelopment? And why is it that we insist on trying to make it harder for anybody to come in and redevelop property? And I will suggest to you why. It's because the Bank of Washington lent millions and millions of dollars to acquire properties from the North Side for the North Side Regeneration Project. $47 million the bank loaned in connection with those properties. It now owes, we think, about $40 million it's still owed. When we did the NGA project, we paid off by agreement some of those liens, so we already had to pay something in extra just to get control of those properties. If we had not gotten that control, that project never would have come our way. And significantly, another thing to be thinking about the purpose for this legislation, we are presently in litigation with the Bank of Washington. They filed suit before the NGA project was closed. They filed a lawsuit in Franklin County, and currently that lawsuit is pending against the LCRA. What did they try to do right before closing? That very legislation sought to rescind all of the transactions involving the NGA and make it so that the NGA would not have clear title to the properties. It created an enormous problem that the very entities that talked about having invested in that area and loaned money in that area, it created a tremendous problem. for the city to overcome, but it did overcome that issue. Today, as we sit here, NSR, the McKee-owned entity, owes at least $1.6 million in back taxes on properties that it had acquired and never developed. And in addition to never developing, the citizens of this state ended up paying out $47 million in tax credits to Paul McKee and NSR in connection with what they were doing there. That's what's happened here. So we've got the bank and we've got NSR sharing the proceeds, getting the money in handouts, subsidies, tax credits. Now we just want to say, let's have all the liens paid for. Those liens, as we all know, could be going towards a condominium in Florida. This legislation doesn't prohibit that. Anybody that wants to resist a condemnation can pour on a deed of trust from whatever property they want to do it and say, I'm going to layer that on. And in the situation that we have now in the North St. Louis, they have what's called cross-collateralized all of their liens. So Bank of Washington has liens on virtually every single property, cross-collateralizing that it has in that area. So effectively speaking, LCRA could not afford to be able to take care of the vacant, dilapidated properties that an ordinance in the city of St. Louis allows them to take care of for these people who have been waiting for decades to get something done in North St. Louis if this legislation is passed. So that concludes my remarks, but I'll answer any questions.
Thank you.
that may
Where's
have.
your office?
Pardon me?
Where's your office, in St. Louis?
At 120, yes.
Okay.
St. Louis.
If you're here, I'd love to talk to you about this in my office. I've got a lot of questions I don't want to bore everybody with, but at some point, today's a pretty busy day, but anyway. So are you saying then most of this is blighted land? And in this case, most of it's just clear cut, right? There's nothing there. It's just block after block of empty land. Banks are loaning more than that property is worth?
Yes.
Why? I mean,
One bank. One bank.
why?
Senator, it's their choice. Part of what I'm suggesting here, like any bank, you make the choice, you take the risk. Why do we say that the citizens should bail you out of that?
Right. So, I expect, and I think most people expect the laws of economics to say banks will do what's in their best interest, which is not to loan more than the property's worth. And you're saying they're cross-deeding these things too? I mean, getting liens on other properties, tying things together?
Correct.
Again, is it the same bank that's doing this? Because it sounds like it puts them at a great deal of risk.
Correct. Same bank is doing all of it. Same bank has lent $47 million. Now, again, we don't know what happened with those tax credits.
Mm-hmm.
There was a trial in which it was disclosed that many of those were fraudulent closings that never occurred. But there was nevertheless a handout for millions of dollars for a closing that never occurred. That was all developed during the course of a trial in the city of St. Louis. So again, fair question.
So you've
why-
got a city block, just one city block, and you do a title search. You might find a half a dozen liens against that one property?
You could have one city block, you could have hopscotch parcels which provides the real impediment right now also. What I mean by that is you don't have contiguous parcels in a lot of circumstances that there's a single owner of. So in that block, for the most part, any bank liens on properties, and I can't say that it's absolutely exclusive, but for the most part, bank liens on the real estate located in that large redevelopment area are all Bank of Washington loans.
Okay. Any questions for this witness? Seeing none. Thank you very much. That's very helpful. Did you have something, Connor? Okay. Next in favor, please come forward.
Is this?
Oh, I'm sorry. Angela?
No, man.
Thank you. Did you bring a witness forward?
Yes.
Thank you. Let us know who you are.
Thank you, Chairman and members of the committee. I am today speaking in opposition of Senate Bill 1466. My name is Neil Richardson. I'm the president and CEO of the St. Louis Development Corporation. and also serve as Executive Director for the Land Clearance Redevelopment Authority in the City of St. Louis. LCRA was established in accordance with Chapter 99 of the Missouri State Statute for the purpose of eliminating and preventing blight while attracting redevelopment. Therefore, the LCRA has the broad authority to undertake activities intended to correct these blighted conditions. Those conditions include the ability to prepare and implement redevelopment plans and projects, contract for services and furthering of those projects, and acquire property and prepare it for redevelopment. The proposed legislation in Senate Bill 1466 seeks to not only limit but destroy LCRA's ability to condemn those properties and pay the fair market value for them. Recently, LCRA partnered with the Project Connect initiative. The Project Connect initiative is made up of the 6 neighborhoods that surround the new NGA West campus. Members of the neighborhood organizations and CDCs came together to create a redevelopment plan focused on removing the blight and clearing the safety and hazardous harm that's preventing them from attracting development to their neighborhood and impacting their overall quality of life. Ultimately, after hearing testimony from both public officials and multiple neighborhood residents, there was an ordinance passed in the City of St. Louis, Ordinance 71795, that gave testimony for hazardous harm that's preventing them from attracting development to their neighborhood and impacting their overall quality of life. Ultimately, after hearing testimony from both public officials and multiple neighborhood residents, there was an ordinance passed in the City of St. Louis, Ordinance 71795, that gave LCRA the power to condemn properties only under certain limited situations. That is for improved parcels where the primary structure has been structurally condemned by the City of St. Louis, vacant lots or unimproved land, but not parcels of land adjoining the same owner's primary residence, or parcels of land owned by a full-time resident of the area or before October 20th, 2023. Commercial and industrial parcels where active or permitted businesses or charitable organizations have ceased for at least 1 year. Commercial and industrial parcels that have been the subject of repeated ordinance violations for multiple violations of the Building or Property Maintenance Code or 1466 will ensure the continued deterioration of North St. Louis City.
Thank you. How did you get the, what's it called, the structure there, NGA, is that what that's called?
The National Geospatial.
How did you get the property with, if this same situation was on that multi-acre site?
So we were working in partnership with the residents at the time that owned those parcels. A portion of the parcels were owned by Northside Regeneration at the time. There were.
So this gentleman that's the problem here did not own any of that property?
He did own some of that property, that's correct.
Did he do the same thing with that then, cross?
No, but he was able to release those liens, Bank of Washington was able to release those liens, and then they were able to conduct a land swap. So to move in those liens to other properties that are within our LCRA or LRA inventory as a way for us to assemble.
Did you have to pay him to do that? Because I can't imagine him doing.
On some of the properties we did,
Okay.
right-size, Northside
Okay.
Regeneration, the fair market value, as well as any other owner of property
Mhm.
in that redevelopment area in which we enacted eminent domain.
Okay, and also, I keep hearing that he's in arrears in taxes too on these properties. Won't this at some point get sold and the courthouse steps in and fix all this?
So what usually happens is they allows it to go two to 3 years past due, and then they pay the taxes up. And then it goes back to 2 to 3 years.
Okay.
delinquent.
Okay.
Before we're able to put it on the actual tax auction,
Mhm.
sheriff's auction, they try to pay up.
Do enough to do, okay, thank you. Any questions for this witness? Senator Mosby, do you have any questions? Okay, Senator May?
No.
Okay, thank you for your testimony.
Just one question. Isn't all of this in residential areas?
Yes, well, there's the majority of the property that's owned by Paul McKee within the blighted redevelopment area is residential.
Yes. Very good. Thank you.
Thank you very much, members of the committee. My name is Arnie C. A.C. Dinoff, State Public Advocate, and I'm opposed to Senate Bill 1466 for the following reasons. I believe that financial constraints just are in play here, and these properties will not be affordable. I'm opposed to eminent domain across the board. This legislation favors basically two parties, and if these properties and parcels are going to be sitting in limbo for generations to come and defeating the entire purpose. There's a lot of abuses in this entire scheme from Paul McKee. And there's a lot of abuses of the Land Clearance Authority. Abuses, neglect, fraud, and especially what happened to the $47 million in tax credits. Mr. State Auditor, I'm asking, if you're listening, for a full-blown, in-depth state audit of what happened to the $47 million in tax credits. This is taking advantage of Missouri citizens. In this case, it's taking advantage of St. Louis citizens who I believe were taken advantage of for the last couple decades with the assembly of this property. It's sitting in disrepair and nothing is being done. For those reasons, I'm highly opposed to SB 1466. Thank you.
Thank you. Questions for Arnie? Seeing none, thank you. Next, in opposition, please come forward. How many are left in opposition? Okay, thank you.
Morning, Chairman, members of the committee. May I approach with some photograph? All right, good morning, afternoon, somewhere in between. Chairman, members of the committee, my name is Peter Hoffman. I manage the Neighborhood Advocacy Program at Legal Services of Eastern Missouri. For 13 years, I've provided legal support to communities across the state to prevent vacant and abandoned property. Vacant and abandoned properties contribute to crime, depreciate property value, impact the public health and safety and welfare of neighboring property owners. They make it difficult to attract new investment and residents to neighborhoods that badly need it. Within the portions of the Jeff Vanderloo and St. Louis Place neighborhoods declared blighted by the city of St. Louis, there are approximately 2,600 vacant properties, equating to 502 acres out of 821 acres that are vacant lots or buildings. 59.1% of the area are buildings in poor condition, and property values have declined over 71% over the last 12 years alone. The photographs I've provided you are just a handful of properties of what residents have to deal with on a daily basis. My office spent the last 10 months working with neighborhood associations, residents, business owners to draft the redevelopment plan that authorizes the city to acquire vacant and code violating properties to remediate the blight. The effort has near unanimous support from hundreds of residents and at all levels of local government. Several are here today in opposition to 1466. I do want to refute the testimony of Senator Schroer. There is no significant mortgage lending within these blighted areas. SB 1466 is a special piece of legislation designed to compensate one single lender who provided a questionable loan to a disreputable developer. Now that the development has failed, rather than protect itself through foreclosure and sell those properties like any other lender would, it has come to Jefferson City asking for a bailout. This is on top of the compensation it will already receive under existing law. For this body to create a special bailout for just one bank is both distasteful and undemocratic. Not only would SB 1466 render the resident plan unworkable, but requiring taxpayers to bail out failed real estate development sets a bad precedent for community projects throughout the state. If the logic behind this bill were extended to other public projects, take for instance the I-70 expansion, it would create a gold rush of bad loans from people expecting a public bailout. To my knowledge, no law exists anywhere in the United States that requires lenders to receive double compensation in condemnation proceedings, and for good reason. Not only would it create the perverse incentives that I just described, it would inflate the cost of public works so much as to render any public project impossible. Over the last decade, the Missouri legislature has provided bipartisan support for efforts to eliminate the scourge of vacant and abandoned properties in our state, passing numerous pieces of legislation. SB 1466 would be a huge step backwards in our shared effort to make all Missouri communities safe and prosperous. I respectfully request that this committee vote no on Senate Bill 1466. Thank you.
Thank you. One quick question. You said a questionable loan. Isn't it many questionable loans, or is it just one big loan on the?
There are multiple loans on some of these properties.
Thank you. Any questions from the committee? Seeing none, thank you very much. Next, in opposition, please come forward.
Hello, my name is Sheila Rendon. I am a resident of St. Louis Place neighborhood in St. Louis City. I have lived there 52 years. I was born into the neighborhood in 1972. I have not seen the neighborhood move in a progressive state in my entire life, with the exception of the NGA project, which I oppose that, but it is in my neighborhood and it is being built. Our neighbors were advised of the existence of an entity called Blairmont buying up property in our neighborhood. We would find, for the most part, purchases being made in the wintertime so that neighbors could not collaborate and discuss that. They were all getting letters asking if you'd like to sell your property, this is an opportunity. The neighborhood is in distress. The city doesn't care about you. Would you like to sell your property? Most people did. A lot of people did not, including my family. Once the properties were emptied, they were used as targets for brick theft. Homes were being dismantled over the weekend. The city could not keep up. When we made complaints about that, then we had 11 fires in the weekend. All of these properties were then changed over. The names were changed to Northside Regeneration. By that time, we found out who Paul McKee was. He was unveiled in a BJC meeting because he had properties and there were bank entities that were involved and he had to reveal who he was. It would be 2024 if he did not have to do that, and we would still be questioning who is destroying our city, destroying our neighborhood building by building. So when we started to reach out to the city for assistance, we wanted to be able to protect ourselves. It seemed that if the narrative was that there was nothing there, it would be no problem with them taking the rest. So the Legal Services of Eastern Missouri helped us to craft legislation, Board Bill 174, that was passed with the mayor's signature last month, that would protect the community and make sure that development was not hurdled by property owners that were resistant to anything that was not in their purview and their vision. We started to realize that the vision was false when we asked if we could do something that would ensure that our neighbors would not be threatened with the thought of nothing ever coming, so you might as well sell. We got that. We went on our own. We put in our own time to try to develop our neighborhood on our own because we never saw anything happening in these past 20 years that property has been owned by North Cyber Generation. Now we found out that on the state level, there's a need to have another hurdle to jump through. We have been doing this for so long, there have been people that have died that just wanted to see the neighborhood turn around. And I don't think that that's a huge ask to try to have self-definition, to try to make your neighborhood something that you'd want to leave your children and grandchildren. That's all we've asked for. We never asked for our neighborhood to be targeted for crime, arson, drug use, homicide. That's what these properties are being used for. We never asked for the city to have to battle out in court to make our neighborhood appealing to others. We like where we live, and that's why we've stayed. But in order to have development, we have to get this one person out of the way. And that's an argument that some of us are willing to have, but it's causing discouragement in the neighborhood, and it's causing people to lose faith in what the city of St. Louis has to offer. We live within walking distance of the new soccer stadium, the Union Station, the baseball stadium, the Battlehawk Stadium. We know that where we live is a desirable piece of land. That's why we're still there. But what happens is that if you drive down Cass and you look to the left into St. Louis Place neighborhood, you'll see wide swaths of vacant land. And in the cases of the vacant property, if it's owned by North Cyber Generation, you have the whole wall that's fallen down and a toilet hanging out. So of course, when people who are not in the know come through our neighborhood, they'll say, well, look at it. Yes, look at it. Bear witness to the fact that this was done to us, and the continuation of it is this Senate bill. As long as we have hindrance in the way, we will never be able to have our neighborhood developed. And we feel like that's the goal, to get everyone to leave. And we just don't feel like that's fair, nor is it possible in some cases. Some people just do not and cannot leave.
Thank you for your testimony. Any questions? Seeing none. Thank you very much.
Thank you.
Next, in opposition, please come forward. And we've got about 10 minutes left total, so if you can.
My name is Virginia Drewy. I live in St.
I'm
Louis
sorry,
Place.
what did you say your name is?
Virginia Drewy.
Thank you.
Live in St. Louis Place neighborhood. I won't be as eloquent as these other people have been. I'll just say I've lived in the neighborhood since 1977. I have watched it fall down around us. Not only fall down, it has become an eyesore. There are many lots that are not maintained, buildings that are half falling down. Of course, no other developer will come into the neighborhood. I don't know why Bank of Washington made loans like this. I don't know why they allowed them to be held for 15 and 20 years with no work being done. But I'm not a bank. I don't need to know. I know it is not the city's problem. It is their problem. They took a risk. They can take a loss.
Thank you for your testimony. Any questions for this witness? Seeing none. Next in opposition, please come forward. I want to thank you all for coming down today. I know it's not easy to get here. Michelle, would you get that?
I had so many I couldn't do single. My name is Ernestine Stewart. I am a resident of North St. Louis, JBL area. And I am here, I am definitely against, and I have a property right next to me that was knocked down from when one of my neighbors had passed away. And for some reason, North Generation and Mr. Paul I don't know how one person can come in your neighborhood and not live there and be able to accumulate that amount of of the area. And I don't understand how a bank would loan someone something that looks like that amount of money that I keep hearing, where we can't even get a $10,000 loan on our home that we actually live in. I'm just trying to figure it out. I don't understand. And I've been working as an educator for 20-something years and retired, and I still, even though my credit is fair, I'm still limited because they look at now, I am retired, so your income has changed, so I'm limited to what I can borrow. But here, this man can borrow off of blighted property that's looking like this, and I got raccoons in the neighborhood now. I've been there 42 years. I never seen a raccoon in my neighborhood. I go out there where forestry is in the county, I see them. We should not see things like this, and where I actually cannot even go on my porch. My neighbor has a garden on this side, so now they're coming to eat out of her garden, so that's a whole family. And I called the conservation people, which I heard the lady say about conservation, called them. They told me if they come and get the animal, they'll bring him back. Is he injured? Because now my area, my home is considered his habitat. And it cost me $350 to get him well, but bring him back to me. I don't understand. But that's what I'm saying. We shouldn't have to fight or have someone get approved for us, and as the elderly, let us have to pay to bail someone out. We all went somewhere and put our money on something, and it didn't work. And your parents might bail you out, but the city, we shouldn't have to bail them out. Our parents, he need to go find his parents if they still here. Tell them to bail them out. We're not those people. And if looking at those pictures, I mean, you all have, I know, think about your area. Close your eyes and think for 1 minute. If this man came in your area and he bought a vacant house here or there by you, and he didn't do anything about it. LRA, when I called them before all of this happened, they would come out and have someone cut something. It'll cut down. Until this man owned this property, I never seen a raccoon. I saw a possum every blue moon. Now I see a family. It's like he's breeding these creatures in my area, and I spend over $100 a month to put down things for rodents and all this, and then the city of St. Louis, they come out and help me and tell me where to put it. It's not fair. And now, here we are. We're here now, and there's no reason for anyone like that to be able, and I don't even know how it was okay. We had a young man recently came to sit in with us. They told him he needed to check before he could get 15 properties, and these are houses that he was going to redevelop. Now, how can you hold something for 20 years and not do anything anywhere else in the city? If we bought the property and we live there and we don't do anything in 20 years, they're going to come and take it. Now, how this man can own all of this and not do anything with it, and plus he bought things he knew he couldn't do anything with. When I called Northside Generation, the lady said, well, we're holding this as collateral. I've been cutting the grass on this vacant lot next to me for over 30 years and can't get it because it's his, but what count? He sent somebody out. But then we've already cut it, because if I don't, I'm gonna have all kind of creatures where I already can't get to my door late at night. So it's like, okay, we're gonna take care of this. So please take care of this for us. Look out for the little people.
Thank you for
and
your
the other
testimony.
senior citizens like myself.
Thank you.
Thank
Any
you.
questions for this witness? Seeing none.
Thank you.
Next person in opposition, please come forward. And we are running out of time. In fact, Holly, I may have you take over. I gotta go to a meeting at 11. Oh, I thought all these people are coming up. Okay.
Good morning. Hi, can you hear me? Okay. Yes. We're so glad to be here. We're Mr. and Mrs. Miguel and Carla Alexander from St. Louis, Missouri, in opposition of Senate Bill 1466. And we represent the Jeff Vanderloo neighborhood.
Morning. We hope this is not about who one knows. It must be about what a developer can do or what he cannot do. You can't borrow, but then expect someone else to pay off your debt. You can't say you're going to develop an area, but then sit on the land you said you were going to develop. You must be held to the same standard as any of us common people. We are against anyone profiting off of other people's misery. Thank you.
And we thank you again. All of us drove from St. Louis to be with you today, representing the children that run by these properties because they're scared, they're on their way to school, and we appreciate your time. Thank you so much.
And one more thing. This property was also in the hands of Mr. McKee, but this is not about Mr. McKee, it's about anyone that's holding on property and not doing something with it. So since 2009, property just been sitting there, and that's over 14 years, and you're getting $320 million of credits, $43 million of credits, and it looked like a war zone, and I was in the service, so I know what a war zone looks like. So we're just, we're fighting for our community.
Thank you. Any
Thank you.
questions? Thank you for coming down today. I know it's not easy to get here. I appreciate, I like it when folks, people that actually deal with this stuff actually come down and don't get paid to. Thank you very much. Anybody else in opposition? That will conclude the hearing on Senate Bill 1466. This meeting is adjourned.